This is Farach. I get to talk to you today about one of my favorite issues, and that's the discussion between mutuality of remedy and mutuality of obligation. And folks get those two confused, so it's always interesting to talk about them. And I'm going to give you a shorthand way of taking a look at those. It's my own way. It's not been approved by any court, so don't necessarily take it to court and say this is what you need to do. But it highlights how you can determine the difference between the two. Now let's look at the concepts. Everybody thinks, or many people think, that mutuality of remedy is necessary in a contract, and that's just not the case. You need mutuality of obligation, but not mutuality of remedy. Think of it this way. Mutuality of obligation is a requirement for there to be consideration for a contract, and if you don't have consideration, you don't have an enforceable contract. Mutuality of remedy, on the other hand, is a method by which you enforce the contract. And so long as it's fundamentally fair, it's going to be upheld by the courts. Why? Because parties have the right to freely contract, absent extenuating circumstances or special situations. What does that mean? What that means is that if you have that consideration, if you have that mutuality of obligation, the remedies don't need to be mirror images of each other, and that's what some people think needs to happen. Now, where did this concept of mutuality of remedy being necessary crop up from? Probably from those special circumstance types cases, such as specific performance or liquidated damages provision cases. A good example of that is the seminal case on liquidated damages, and when those clauses are enforceable from the Florida Supreme Court, called Lefemine versus Barron. And I'll read a quotation from that particular case, which demonstrates how the confusion can come about. That quotation reads, "We recognize that a lack of mutuality of remedies between the parties may be a separate reason why a court may refuse to enforce a default provision of a contract." And it cites a 4th District Court of Appeal case called Blue Lake Apartments versus George Gowing, Inc. Now that sounds like mutuality of remedy is necessary in order for there to be an enforceable contract. But if you look at the circumstances of Lefemine and you look at the circumstances of Blue Lake, you'll see that it's not the case. In Lefemine, the question was, at what particular point is it fair to say liquidated damages are enforceable or the party not having to prove actual damages? In other words, is there fundamental fairness in the mutuality of remedy? Now, this situation is even more apparent in the Blue Lake Apartments case, because in that particular case, the seller in the real property contract had a heads I win, tails you lose type of situation. If there was a breach by the seller in the Blue Lake Apartments case, what did the buyer get? The buyer got the opportunity to get their deposit back. No damages, just a deposit back. In other words, the buyer got the opportunity to get nothing. The buyer could not get anything if the seller breached. However, if the buyer breached, the seller got to keep the deposit. In other words, there was unequal pain from both sides, on both sides, because in that situation, the pain only flowed against the buyer and none of it flowed against the seller. Unequal situation in terms of pain, the court held in Blue Lake that that's not enforceable. All right, how does that work in the most recent case of the 4th District called Antwerp? In that particular case, the 4th District looked at a lease which had an unequal, what appeared to be a remedy provision. Specifically, it looked at a lease which said that the lessee waived trial by jury. Didn't say anything about the lessor, it just said lessee waived trial by jury. Lessee, of course, said, wait a minute, that's unequal remedies. There's a lack of mutuality of remedy, and that particular provision is not enforceable. But the 4th District looked at it and said, no, not really. Why? Because it's not a question of there being a remedy, it's just how you deliver that remedy. Now, keep in mind, or think back to that provision I told you about, that principle I told you about, what I call the pain principle. In that situation, there will be pain, no matter whether it's a pain that's delivered by a jury or a pain that's delivered by a judge in a bench trial. So even if you apply that provision strictly according to the lease, there will be pain. How you get there might be a lot different. Some parties will argue that it's not right that it be done that way, but that's okay. So if you look at the three concepts together, they make sense when you apply the pain principle to mutuality of remedy and mutuality of obligation. I hope that helps a little bit. As always, if you have questions, call me at 561-803-3500, or you're always welcome to send me an email, mfarach@richmondgreer.com. And of course, go to the blog and you can check out the entire case law update for this week. Thanks.